Actually, I had taken a flat and he had allotment, new allotment letter. This was way back in 2003. And in that it was mentioned this was under the Ownership Act. I am giving such and such flat and total consideration is of certain amount. Out of that you have to pay this much and balance at the time of possession. No payment, this thing was there. What you call as a slab payment or something like that. Straight away the total consideration out of that 2/3 to be paid and balance at the time of possession. That was the fact. After so many days, he had not entered into an agreement for sale and all. In 2008, without my knowledge, he sold it flat to somebody. And I came to know that he sold that flat for a certain amount, which was 3 times the normal amount what I had bought. I had gone to him, he said, sorry, I have sold the flat, now I have no alternative, you have to make the settlement. I said, what settlement you want to make? He said, you have paid me 2/3 amount, I will pay some interest on that and you take that. Sorry. So, particularly in this case, whether I can go to the consumer forum or not.
You can go to the consumer forum. Proportionately on a pro rata basis, you would have to show what is the market value. Now today, if you buy a flat, how much would you have to spend? 2/3 of that, he has to pay you along with compensation and costs. You can go to the consumer forum, maybe market value. Not only that, I would suggest that to put extra pressure, if you do have the time, you can file a complaint under MOFA section 13, a criminal case against the builder and the directors or the partner, which will put additional pressure on them. They will be convicted and imprisoned. Because the law is that the builder cannot accept more than 20% without entering into a registered written agreement.
My name is Nagia. Mr. Gai, during the presentation you said that if somebody is buying a second house, he will take it as an investor, not as an owner.
No, you will have to justify. Supposing, let's say, he's buying it. He's buying it for his parents, aged parents, and they want to shift together. You have to substantiate. Only if it's an investor.
The second home is becoming a norm now. In fact, I stay in a house in Mumbai and I have purchased a house or booked a flat at an outside center to have it as a second home. So this is one home.
So then you have to justify that it's a holiday home, it's a bungalow in Mahabaleshwar. You have to show that
this becomes a fit.
You have to show that it is not as an investment basically for your own use. You may have one home, one bungalow in Mahabaleshwar, you may have one in Nainital, perfectly permissible. But supposing you buy 3 flats here, you are an investor. You can't be staying in 3 flats.
Okay.
You have to justify that. Or you say that, okay, I am staying here, it's difficult, the flat is small, so my parents, my in-laws, we are all in the same
Okay, fine.
locality. You have to justify that.
Line to that is if the builder at the time of accepting the booking gives a time frame for delivery of the handicap possession. If he defaults, the one default is okay, 2 default is okay. If he defaults multiple times, there will be in our case the builder has defaulted 4 times in honoring the commitment for handicap possession. Will it be a fit case for being taken to the consumer forum?
Definitely you will be entitled to interest for a period of delay. And supposing you feel that it's just postponing and there's no chance really of getting possession.
No, chance is there.
You can even pay the market value of the flat.
Chance is there, but then the builder has been denying it.
So if there is a delay, you will be entitled to interest if meanwhile you are staying in some alternate accommodation and you can produce those agreements to show that they are consequential losses caused to you.
Is any government authority exempt from the action under the contract?
Sorry, is any government authority?
Exempt from consumer function.
Only sovereign functions of the state, otherwise no authority is excluded.
All are
Only sovereign function of the state is excluded.
Hello sir, I'm Nitesh here. Now my question is how to quantify the damage or suffering. Suppose I want a claim of 25 lakhs. And how I can quantify okay, I have got a suffering of this much time and I want a claim of 25 lakhs. So how can I quantify it?
Mental suffering is something which differs from person to person. So it will be estimated what the judge thinks is reasonable. It will not be given just because you say that you have faced so much mental anguish.
So, but how I can present it?
Otherwise, only what can be scientifically computed can really be claimed. The rest is the discretion of the forum, whether it's considered 5,000 reasonable, 10,000 reasonable, 50,000 reasonable. People do file exaggerated claims, and that looks as if that is counterproductive, because the court thinks that you are trying to capitalize on the situation rather than really be an appeal to consumer. So don't try to make inflated claims, be reasonable and practical.
So, I have two queries. Indian Railway Act, there is the maximum for lakhs rupees compensation.
Sorry.
In Indian Railway, there is maximum 4 lakhs rupees compensation as per Railway Tribunal provision. In case of death. आपका मैंने एक आर्टिकल पढ़ा था जिसमें आपने रेलवे ट्रिब्यूनल कोर्ट को ओपन करके कंज्यूमर फॉर्म में 25 लाख रुपया compensation रिलीज को बताओ.
Railway Claims Tribunal can deal with cases regarding the railway accident.
Right.
Consumer forums are debarred from entertaining those complaints. If it is not a railway accident, but just some accident due to negligence, you can claim compensation under a Consumer Protection Act. Like there was a case where the corridor between two compartments was left open. The person fell down and got killed. There's no railway accident. He fell down and he died. He could claim compensation.
तो रेलवे फॉर एग्जाम्पल 2 ट्रेन का एक्सीडेंट हुआ, उसमें मैक्सिमम डेथ रेट 4 लाख रुपए का, उसमें हमने 25 लाख दिला.
Then that can't go to the consumer forum.
A couple of queries based on what you said at the beginning. One was, you given the case of a broker agreement, that you have agreed to certain things. Now, such transactions you have to go if you have to go for this. Is there any remedy? And similarly for taking delivery of a car, you have to sign that.
The remedy is, I'll tell you, for both
Yeah.
things. The main thing is buyer beware, target and
Right.
So if you are signing something, it's fine. But then whatever advice is given to you, you have to evaluate whether you want to follow it or not. That is your lookout. He may suggest something, but whether to accept it or not is up to you. So you can't blame him. Like I may tell you that I know XYZ is going to, the prices are going to increase tomorrow. Now if you invest, it is your lookout. I have just given you a tip or a horse, something like
But at
that.
the time of buying a car, you don't know what can happen.
No. Now again, if they say you sign, this is subject to trial and sign.
Right.
So that it makes it clear that you have taken possession and delivery of the vehicle without the trust.
So you have to put it on.
Okay.
The other point I want to ask you is, suppose I've already approached the High Court for regarding this, similar cases, what they said about government letters.
You can't approach the consumer.
You can't.
You can't approach two civil courts together. You can have one criminal case and one civil case together. It's fine, but not both simultaneously. If you feel the High Court is taking too long and you want to come to the consumer court, then you have to withdraw, but with liberty to approach the consumer court. If you simply withdraw, it means you are giving up your freedom. But withdraw with liberty, you can approach the consumer court.
Actually, my mother passed away last month due to adverse drug reaction. Actually, उसके घुटने में दर्द था, तो she went to the Ayurvedic doctor with the intention कि उसका कोई side effect नहीं होए. And the doctor is a DNS and she gave allopathic medicines to her. So alloparin content था, उसके वजह से TEN करके toxic epidermal necrosis करके जो skin related disease है. So in that she passed away. So we want to lodge a complaint. So how to go ahead with
Any
that?
postmortem done?
Postmortem was not done.
Then it is very difficult. How would you establish that?
Yeah, but in the death summary, it is already mentioned that she had a good pain and she took that medicine. And after that, because this TEN causes only because of adverse drug reaction. So in the death summary, it is mentioned.
No, if it is a known adverse drug reaction, this is something which cannot be answered like this across the dais. Because in case of adverse drug reaction, it's a known and documented cause.
Right.
So that means there is no negligence. Now that leads us to the next question. If it is foreseeable and anticipable that such a thing can arise, what action was taken to prevent it from occurring? Is there any action, like a test dose to be given or something like that?
No, nothing was.
Is it possible? Next, after it occurs, could it have been arrested and curtailed?
Okay.
Should the patient be monitored? So medical cases are not that simple. You have to consider a whole host of aspects and
Right.
decide whether there is negligence or not.
Okay.
Because the moment you say it is a medicine, that means it is being prescribed. If you say ADR does occur, then it means it's a known complication.
Okay.
Inherent risk.
Okay.
In your lecture, you mentioned that the doctor and the hospitals where there is paid patient and free patient, only they come under consumer. So do the government hospitals come under consumer?
Many government hospitals do have both categories of patients.
And the
So
hospital,
there are totally free, they don't. Totally paid, yes, covered. Free and paid, covered. Totally free, not covered.
totally free not covered.
Totally free, not covered.
The point is that regarding that implementation of order penalty for not adhering to the order given by the consumer court, is that same penalty levied for an ombudsman also on a TPA if they don't honor the...
Whoever is supposed to comply with the order, the ombudsman does not render any service. So you can't proceed against the ombudsman. The TPA, if the TPA is directed and the TPA does not pay, the TPA's local person can also be sentenced to prison.
Well, you have a very bad experience about ombudsman. I have, let me tell you, a good experience with ombudsman.
No, if you tell me one word, I'll tell you
Then not one, that will be...
So I think let's go to the next
Okay.
question so that we can get there.
Sorry. The question is that ombudsman, I mean the last ombudsman seat was vacant for almost a year or so with the result there were more cases. So my worry was that if I have to take the case from ombudsman to the consumer court, is there
You can any time approach the consumer forum during the pendency of the complaint before the ombudsman or after, or even bypassing the ombudsman.
But what about the time limit? The time frame is 2 years.
2 years from the cause of action, it was pending before the ombudsman. It is not as if you were not taking any action.
Can the insurer, change the premium for say Mediclaim? If I had the Mediclaim and paid the premium for say for 2 decades or more than that, suddenly I become senior citizen. Can he increase the premium?
If the slab changes,
But there's no intimation of that.
if the slab changes, because it is in 5-year slabs. So if your age changes, they can increase it. But they cannot increase it like they cannot load the premium unless there is a provision in the policy. In all the old policies, the provision was that in case of a no claim, you get 5% cumulative bonus. In case of a claim, the bonus is reduced by 10%. So they cannot load the premium. That is something illegal because it's not within the terms of the policy, but they do it. But automatically, since the cost of living goes up, premium goes up. So if you are say 70, I am 70, our premium should be the same.
Another thing also what they do, suppose you make a claim, even after 30 or 35 years of paying the premium, you make a claim for any amount, they load the premium for the next year. Or
That
next
is
3
totally
years.
illegal.
But they are doing it.
They are doing it because it's a cat and mouse game.
What do you do?
What happens is, they do it for everybody. You send the notice, they are not coming. Out of 10,000 people, 200 will complain. 50 will send the notice and 10 will file a consumer case. They just wait for the outcome and refund the amount. At least for the remaining 990, they continue to pocket the premium. And for that, I would really blame our judicial system because although we have time and again emphasized and pointed this out, no general directions are given. They say we have to consider it on a case-to-case basis. If general directions are given, then it would solve the problem further.
Can I ask a question in connection with that? I think one of the things that's happening is there's one individual who's filed a public interest litigation which has led to a lot of changes in insurance, which is Government Damani's case. And I think the new Companies Act now allows class action suits. but we just don't have enough people who will come together to file it as a class action. And I think Gaurav is trying to see whether his PIL can get converted into a class action. But just one point I want to make to this audience, which is that everybody sits around waiting for somebody else to file it. And even as an organization like us, we are just 4 years old, we do not have the resources to take up anything as a class action. But people want all the help free, and they want it on the basis of one letter. If you want them to get together to file a class action, we will not even get 50 people who will come fully with their documentation to do it.
In fact, I have seen Gaurav Damari's petition, and most of the points raised is various level judicial products. Only there is no single composite general guidance. That is what is
no, which is why now in reaction to this case, because it is a PIL, at least some general directions have been given. As in, IRDA has reacted and it has changed a lot of rules which have become
but
a
they are
little more
contrary to the
customary.
Supreme Court judgment, because they say now this can be done, that can be done. When the Supreme Court judgment says you cannot change the terms of the policy, IRDA says you can change it.
So we would love
In my policy of 1996, I have ordered on the same terms and conditions. Why should IRDA go against the Supreme Court judgment and say that no, you can change it? IRDA is doing many wrong things. In fact, I'll tell you, I think I would like to share this bit of information which I learned. You know, people are shouting against doctors, saying they don't want to accept cashless. What is the main thing behind the scene people do not know? The insurance company is not giving you cashless. Who is giving you real cashless facility? It is a doctor who is, or a hospital who is giving. You go to the hospital, you get admitted, you take treatment, you walk away. The insurance company has then to reimburse the hospital. So till then, cashless has been provided by the hospital. What the TPAs do is that they try to bargain with the hospital. We have so much money outstanding. If you want prompt settlement, you accept 80% and settle. Otherwise, we will delay it for 6 months. That is why doctors are agreed. This was pointed out to the IRD at a public meeting where one of the topmost officials of IRD was present. And he said, it's a question of economics. How can you have economics and encourage something which is illegal? It's public money. How can the TPA pocket that money? They take it from the insurance company, give it to the insured or the hospital. Then a very wishy-washy reply that, okay, no, it should not be done. They said, why don't we take action? No, see, we are regulators. If we regulate, we regulate everybody. If we can't regulate everybody, we don't want to regulate. And then what is this nonsense? It's like saying that a traffic cop catches a drunken driver and that person says that no, there are so many other drunks, so many getting away, so why should I be caught?
Just throw some light on what's happening in banking as well, because we hear banks say people approach the consumer forum where they should go to the banking ombudsman. We find that the banking ombudsman is very narrowly defined. So any cheating that has happened by a third party, like an insurance agent or a mutual fund, is not even entertained by them, other than to see whether you've signed on it or not. They don't look at the product. So what is your advice? What should people do?
Again, banking ombudsman is totally useless. I'll give you a real life instance where a person challenged some transactions. I won't get into the nitty-gritty. The moment the complaint was lodged with the banking ombudsman, the bank writes a letter saying as a gesture of goodwill, we are waiving these charges. Why gesture of goodwill? I don't want your goodwill. It is a matter of right. You either give it to me as a matter of right or I don't want it. And it asks the ombudsman to decide. Ombudsman closes the case. And there's no compensation, nothing. So the bank has very charitably waived off what it was not entitled. I'm not happy with it. In fact, I'm not happy with any of these ombudsmen or regulators. TRAI, Telecom Regulatory Authority of India, is equally bad. Not doing anything.
We need your help then, because the RBI is now coming out with a consumer charter and they've got 9 points. I would like to email it to you because first of all, we have taken the stand that the charter is not good enough if it's not backed by some kind of action, time-bound action and penalties. But we would love to have your experiences so that we can make a representation to RBI.
Sure.
Mr. Gai, good evening. My question is regarding Mediclaim. I recently switched from Mediclaim 2007 to 2012. The reason I switched was they said the maximum sum insurable under Mediclaim 2007 was 5 lakhs and under Mediclaim 2012 was 8 lakhs. And since the amounts, this is with New India Assurance Company, since the amount they gave for the room rent is 1% of sum assured, and if you want a single room, then the charges are more about 6,000 or more. So I thought that 8 lakhs would cover that amount. Then the kind of nightmare started. They asked me to sign a migration form. So I said, why should, I'm just renewing my policy. They said, no, but this is a new policy. The kind you mentioned, they don't have a right. And my agent, so-called agent, is the development officer of the insurance company, not an agent. So I said, it's not fine. I guess you have to sign some documents, for the change. So I signed the migration form. After I signed the migration form, I realized that the terms and conditions were different, so I again brought it to his notice. One of the main things was the no-claim bonus. I enjoy a 50% no-claim bonus because I have never taken any Mediclaim. There's no claim. So they said, now that no claim you will not get any longer. But since your policy was worth 5 lakhs and you have a 50%... So 5
lakhs, 50% no claim bonus would have already given 7.5.
Yeah. You see, every policy is different. I understand that also. This is a family Mediclaim, so it is for the entire family. Floater. So he told me that you will now get 50%, which means that if your no claim bonus 50% of 5 lakhs is 250,000. That is all that you will get as an absolute sum and no more in the new policy. There were a number of such things which I did not understand, and it was very difficult because ultimately you ask the insurance people yourself, you don't go to a lawyer, you don't go to an activist. Final thing was, they gave me a policy, but the payment which I had made 20 days before the expiry of the payment was encashed 15 days later. What is the implication?
That makes no difference.
That makes
in law, the payment made, a check encashed at any point of time, relates back to the date when it was handed.
The other thing was,
Sir, you have a question? There are others waiting, so can you finish the question quickly?
Yeah, they did not give me the discount. I was entitled to a 10% discount because I had no previous claim. However,
it becomes a new policy, so
they become a new
So that is where I say buyers beware. Make sure, see the new policy, read the terms and conditions, then take it.
No, they said...
Otherwise, this is a rampant practice.
No, but they said that we are not giving
Don't
10%.
see the moment you say this, you are relying on your opponent, on a person who has vested interest to guide you, or rather to misguide you.
Well, sir, you have come to a Moneylife Foundation event, and I'm glad you're here. We have probably written more cover stories on insurance. We have about 20 cover stories. Now that you've discovered us, we run an insurance helpline, which is free. So maybe, there are others in the room who have questions like you. You don't need to go to a lawyer. We also run a legal resource center where we try and answer people, which is again free. So maybe people out here can take advantage of it sometime.
Here primarily something that's going to interest Sujata and because she mentioned RBI. I've been at Invisible Bank credit cards since October 2012, and I have an agreement and everything to come to you today. And I even forwarded them that I'm attending this session today. What they have been doing is, and I have it documented, as you said, I've been documenting, even my phone calls. And what they are doing, after I conducted a forensic audit, just sat my auditor down and I said, let's do this. They are the only credit card company in India that charge you interest the moment you incur a charge. I used to be in Diners Club myself, and we ran a really ethical company. And I spoke to my ex-boss also, he said, write to RBI. I wrote to American Express, where also I have card, and I said, when do you charge interest? You know, the late payment fee. Because I knew the bills I was getting was wrong. I wasn't spending that kind of money. So, and this is since October 2012, all documented. So it turns out that they charge immediately. Everybody else charges, you get your bill, and you're given a due date by which you pay your interest. Or by which they start levying interest if you haven't paid. So do I have a good case or not? They are charging, and I keep saying, send me a snapshot of the RBI guidelines. Send it. Send me the link. Send me anything.
The charge can be levied only if you do not pay by the due date mentioned before.
Thank you.
Not at all.
Thank you. This is what I've been saying, and I've got other credit card companies also.
Hello sir, my name is Pradeep. I purchased a flat from a builder 1.5 years back. He collected 2 years advance maintenance money from me. Some 8-9 months back, he formed a society and handed over the maintenance of the society to the society without handing over any balance funds that he had. Now the society is asking me to pay the maintenance amount. And the majority of the society it comprises of people who have been living in the society for more than 4 years. So they don't face the problem of having unamortized maintenance, advance maintenance. So how to deal with this? So is it a case between me and society, or me and builder, or between builder and...
When was the society formed?
9 months back. 9 months back.
Okay, it is the duty of the society to take the accounts from the builder.
Right.
If they don't do it, then both the society and the builder are equally at fault.
So it is between those two.
Yes.
So I don't need to pay anything.
No, otherwise, if they raise a demand, see, you have to live in the society. He will keep on billing you. You have to be then proactive and proceed against the builder and the society.
Both.
Right.
So do I need to go to the consumer court or the cooperative court?
Choice is yours, but consumer court will be better.
This is regarding the club membership. The club membership registered office is in Hyderabad, and they had a branch office in Mumbai. They have sold the membership in Mumbai, and whatever commitment made, they have not fulfilled. So now, if I have to file a case, where I have to file? Because that receipt.
Cause of action, they have operated through the Mumbai office.
Yeah.
So the cause of action has arisen here.
Because the receipt what they have given, they said the jurisdiction Hyderabad. That's the reason.
They name it in jurisdiction Hyderabad because that is where a corporate office.
Yeah.
So the choice will be yours. You can file in Hyderabad.
No, but I can file it here also.
You can show that the transaction took place here. You can file it.
Yeah, because whatever receipts and bills they have taken from Mumbai office. So we can.
So cause of action has arisen here.
Thank you.
Airlines routinely give their employees free passages, but they collect some part of the payment towards taxes, etc. So these employees do have the same rights as full-fledged passengers in terms of consumer efficiency.
It is a purpose. In fact, there is, this question I can answer on the basis of a Supreme Court judgment. The railway employees admitted to railway hospital free of charge was discussed by the Supreme Court. And it was said that any service provider as part of a purpose or an employment benefit is available to consumers.
Thank you very much, Jehangir. Let's all give Jehangir a